with our compliance and legal panel. Some say the sexiest panel of the day, although we've had a heck of a lineup already so far. Hope you are all enjoying Tokenize This. What a panel I have today of three incredible attorneys, all with their own value add in some capacity in this space. I'm going to give them a chance to introduce themselves, though I have the pleasure of knowing all three of them quite well, and well enough to know that when you speak with a bunch of lawyers, you start off with a disclosure. So this goes for the entire, conference, as we've been saying it, but specifically remember, there is no legal advice we're giving here. Certainly no investment advice either, but you are going to hear it from some of the top experts in the space. So I'm excited to get into it. Adrian, you and I have been a business partners for over 10 years now, which is incredible to say. Some people are questioning
some gray beards.
That old. Exactly. But why don't you go ahead and tell everybody who's watching and listening who you are?
Sure, it's a really pleasure to be here. This is an amazing conference you guys have put together, and I'm really flattered that you guys asked me to be on here. I'm Adrian Alvarez. I'm an attorney. I also have an MBA from the University of Miami. Been in the financial tech space now for, like I said, over a decade. Herwig and I founded the company InvestReady, which was at the time called Accredify back in 2013. And we do accredited investor verifications for Reg D 506C issuers and platforms. I've also been doing consulting on the security token space for a few years now, also along with Herwig and independently. And then just in general, we help with different issuers and allow them to be able to connect with the investors and provide the service through our own InvestReady platform as well.
That's awesome. And Daniel, I've had the pleasure of actually, retaining you and working with you directly, as well as, some of our clients on the advisory business have worked with you, all amazing rave reviews. Why don't you tell us a little bit more about your background and how you help the space out?
Well, thank you, Herwig, and good to be here with everyone. I'm Daniel Stabile. I co-chair the digital asset practice at the law firm Winston and Strawn. And equally important to me is the extracurricular work that we do. We wrote the first law school textbook on digital asset regulation, and I've proudly been teaching as an adjunct a digital asset regulation class at the University of Miami Law School since 2018. And we're doing everything we can to try to ensure that the regulatory environment stays fair and reasonable in the United States and creates an environment in which innovation can flourish.
Yeah, spot on. And I like that reference to the Hurricanes. That's an alma mater for myself and for Adrian. So go Canes. But last, certainly not least, Mr. Marc Powers, I get to have an amazing thing to say that you are both an advisor and investor in our company, as well as been pretty involved in one of our research consortiums. You have your own Powers Hour, where you actually go into it with many of our community to talk about the regulatory landscape. I know you're retired now, but you're still doing a lot for the space. Tell us your revered history, the incredible stuff you've done, and then how you're participating in the digital assets ecosystem today.
Yeah, Herwig, great to be here. I'm thrilled that you have so many people signed up for this program. I think it's fantastic. This Tokenize this 5 years after you guys founded this being the inaugural one and being part of it is amazing. And it's great to be here with Dan. I actually, when I was going to start teaching and I asked, figuring out what I was going to do as my third or second act, I actually knew that you were down in Miami, and I had talked to, FIU, Miami, a bunch of other schools down here because I knew I wanted to spend time down here. And so it's great to spend time on a panel with you. And Adrian, I knew of you because of through Herwig. I do want to throw a shout out again to Powers Hour, if I may, because that's the subscription service of security token market or group that they throw together, and once a month I pontificate on whatever it is that we think is kind of current and new and interesting, and people are able to kind of interact on, and when I go through analysis on generally different cases that come up. And so I will make one further correction, and that is I'm not retired. without something after that. I'm retired from law firm practice. That's how I kind of talk about myself. So I kind of figured after 40 years of practicing, I figured it out. And so so now I spend my time teaching at FIU, both blockchain regulation and fintech law, one class a semester. And my career is, I started my career at the SEC in enforcement, first 5 years. As I was saying on the before we got on this open live mic, the case that I worked on as a junior lawyer at the SEC was SEC v. Aquasonic Products Corp., which involved geographical dental licenses, which the SEC brought an action against the parties participating in that and claiming that they somehow were issuing investment contract securities that should have been registered. And that case, we argued, was a security. It went up to Second Circuit. It was affirmed there. And that has become one of the seminal cases up in the Second Circuit that still is vibrant and is still cited even by current cases, all of which in this token space, security tokens. And so I think I have a little bit of understanding what an investment contract is, given that, of being involved with it for 40 years. Since then, I was at the last 20 or 50 law firms, Reed Smith and then Baker Hostetler. I moved over to Baker Hostetler to build and lead a securities litigation, SEC defense practice. And then I also began its hedge fund industry practice. And I left in 2020. And maybe a little bit longer than others, I apologize. But that's my background, and it's thrilling to participate and hear from other people's point of views on things and have people hear what I have to say.
No, I think that's great. Again, we've got an incredible panel. We got, both perspectives, even though you're no longer with the SEC, we do have kind of your thinking there. We also have, Daniel on the other side, and then Adrian, who's actually one of the technology providers, providing a lot of the compliance software that helps power and make a lot of this technology legal in the first place. But before we get too technical and dive into the tokenization side, I think I'd be remiss that especially for everyone in the audience, the number one thing on their mind is probably, what do you all think about Ripple? And again, we're going to stick with you, Mark, because another toot for the Powers Hour horn here is you correctly predicted actually some of the outcomes in the past for some of the things that are happening. And so, I think it's great to get your experience, what you thought about the Ripple outcome, and maybe how that might affect the landscape moving forward.
Sure. So what's the landscape look like? And then I'll get specifically into the Ripple case. I think the landscape is pretty clearly set up that with, you have a chair, Gary Gensler, who I thought, unfortunately, correctly, that knowledge is good and bad. And the fact that he had a tremendous amount of information, knowledge about blockchain and experience with it before joining the SEC and teaching the subject at MIT, people weren't sure if that was going to be good for the industry or bad. In my opinion, it turned out to be bad, right? And I thought it might be. And he's used, and I also knew, based upon his experience working at the CFTC, being the chair there, he was the only agency in the entire of all the various executive agencies, administrative agencies, that implemented every single rule and requirement of Dodd-Frank, the only one, okay, by putting in swap exchanges and doing all these, and the like. So I also knew he was very ambitious and aggressive. He's now bringing that to the fore with this in the area of digital assets / blockchain regulation. And so in the short version of this, if I may, is that the only way, in my opinion, things are going to continue to advance, not just for security tokens and fully regulated businesses that are using blockchain, but for those that are going to be outside of the regulatory sphere of the US and SEC. The only way that's going to happen, in my opinion, is either through the courts or through Congress, because Gensler's not going to do it. And it's clear he's not going to do it. I mean, he went, we'll get into it maybe a little bit, but if you think about it, Coinbase he went after because it's it breached the traditional way that the federal securities were set up of segregation of businesses, right? And he called out a conflict, an insurmountable conflict. So he's suing them for registration violations of being a broker-dealer, being a clearing agency, and for selling unregistered securities, all because it's all housed within one platform, the way that it's currently operating for security cryptocurrencies currently. So with that background, I also thought all along that in the Ripple case that the judge was playing down the road and would likely not give the SEC certainly the injunction. I wasn't sure whether or not she would ultimately find it to be a security or not, but ultimately she found it wasn't. And maybe that's not, it's the rationale one could question, because it ultimately, the way it's set up and the way she set it up, it provided for giving more disclosures and information to institutional investors who generally needed less than to retail investors. You know, the way, if you kind of cut through it. But I think from my early days from dealing with her in that case and following her rulings and participating by observing some of the oral arguments early on in the case, I thought she was going to be sending a message, and she did. That's what that case is about, because two things occurred. One, you know, I thought that maybe she would not find it security, but I'm not going to grant the injunction, which she could have done potentially. She could say it's not going to repeat itself, and she could have done that in the Ripple case because they're just an issuer. And as an issuer, all they had to do was say, we won't do that again. Or she could say there's not no likelihood of future violations. And she could have gone that route. But she went the full route of saying there's no security. So what happened there is you have the Ripple case where she's clearly sending a message to the SEC. You should start thinking about reforming or being more accommodative to the blockchain space and what's going on in CeFi and DeFi, centralized finance and decentralized finance. And I think by her recent denial of the SEC's recent request for review to the Second Circuit immediately was fantastic from my point of view, because it really will hopefully put the SEC's feet to the fire. The only way you're going to bring them around is by forcing them to come around, because I get to my second point, if I may, and then we'll go back to Ripple and have everyone else's input on and their viewpoints on it, is the Grayscale case. It's a triumvirate. There are three major cases that are out there. So Ripple, we have a decision. The second one I thought to be also a favorable decision and was Grayscale. Okay, that involves issues relating to transforming a prior product of Grayscale, which is a registered asset manager, of commodities, or Bitcoin, Ethereum, and other kinds of potential securities, but an asset manager that was trying to convert their trusts, which they created using Davis Polk, you know, to set the whole thing up in a regulatory compliant way, to turn it into an ETF. And Gensler, because he controls the agenda and gets to direct the way he wants to have things come out. And there is, as we know with the SEC, the way it's structured, there are two Democrats, there always will be two Republicans, and the chair gets to be picked by the President of the United States. So that always provides for a 3-2 majority for the chair to have him followed or her followed, which is generally the case. And in the Grayscale case, he has, along with others, has continuously denied allowing a spot ETF, to be clear. It's a spot ETF we're talking about, to be allowed to be offered to retail investors. The DC circuit in that case knocked down the SEC again there too, basically saying their decision to deny a spot ETF when they allow futures ETFs to be allowed and traded on marketplaces was arbitrary and capricious. I thought that was going to happen, and it did. It was fantastic. The third shoe that's going to fall. So I believe by the end of this year that the SEC have no choice but to allow ETFs. Maybe they'll try and punish Grayscale and not let them be the first one. They'll push BlackRock ahead or something like that. We'll find out. Which is also a secret ETF. But I think the third shoe to drop, and again, it's a court, right? It's not the SEC voluntarily doing any of this. I think is the Coinbase case. Not the one where they're suing them for unregistered violations, which I mentioned before, but the one in which Coinbase is suing the SEC, which is being heard in the Third Circuit for failing to put forth regulations around blockchain advancement, and adoption. And I think there too, if you read what this, if you saw part of the rulings there and part of your arguments, or the rulings, if I may say, I think there too, the SEC is going to lose. So the landscape, things will improve, not just for security markets, security token markets, but generally for the cryptocurrency markets overall, not because Gary Gensler wants to have that happen, only because he's got no choice.
Daniel, do you agree with all that? Do you think the SEC,
even some of it? I don't know.
do you think the SEC is going to also take a couple losses here in the courts? How do you feel about the whole situation, given you have a whole host of clients in the digital asset space?
Yeah, I do agree with much of what Marc said. Let me just raise sort of a few points that I think are very significant. It's probably no surprise to our audience here that really the hallmark of the regulatory environment for digital assets in the United States is a lack of clarity. Unlike other jurisdictions in the world, there's no federal statute or regulation that governs the treatment of digital assets. And that's a problem because digital assets can have a nearly infinite variety of different properties and characteristics. So figuring out the taxonomy of which of these are securities, which of these are commodities, which of these are currencies is really important. And Marc's right, the SEC here is taking a very aggressive approach of regulation by enforcement. There are people within the SEC, including very senior people, including commissioners of the SEC, who disagree with the approach. And there are other regulators in the federal government, including those in the CFTC, our commodities regulator, who disagree with the approach. So the battle that we're fighting in the industry is on two fronts. And I think that there's a relationship between the two fronts. The first is Congress. And unfortunately, I think the issue has become balkanizing. And it need not be that way. I mean, for many years, I've argued that this should be a bipartisan issue, and that there are things to like on both sides of the aisle of digital assets. And the most consequential piece of legislation right now is indeed a bipartisan bill by Senator Gillibrand from New York and Senator Lummis from Wyoming, who probably don't agree on many things, but they do agree that the SEC should be divested of jurisdiction over many different types of digital assets. So there are efforts to educate Congress right now and impress upon them the importance of having a clear and fair regulatory environment for digital assets. Right now, what is a security under US law? We're looking at statutes that were passed in the 30s and cases from the 1940s. And generally, the SEC is trying to shoehorn digital assets within the sort of catch-all phrase investment contract, and that's creating all sorts of problems. So the second front is in the courts, right? And I agree with Marc that there have been some important victories. There have been some important losses as well. So not long after Ripple, another judge in the same court, the Southern District of New York, which is one of the most important courts in the United States, issued a decision that really called out Judge Torres's decision in Ripple and disagreed. But there is one thing in common between the two opinions, which I think is very, very important. Unlike what many of us on this panel, presumably, and many people in the audience, I would assume, regard as traditional security tokens that have features and characteristics of what we think of when we traditionally think of as securities, equity interest in a company, some sort of profit sharing, et cetera. With many of the digital assets that are the subject of these cases, you don't have those properties or characteristics. And what both Judge Torres in Ripple and Judge Rakoff in Terraform said is that those digital assets themselves, XRP and UST, are not in and of themselves securities. That is really important, and that's something of a nuanced issue. The point that they were making is under certain circumstances, they can be sold in investment contracts in the same way that oranges in the Howey test, this is the seminal investment contract test, oranges are not securities, but they can be sold in a securities offering. So really the highlight from the decision in the Ripple Labs case is that the primary issuance, the direct sales from Ripple Labs to institutions of XRPs, that was probably a securities offering. That was a securities offering as the holding, because at the time, Ripple Labs was still sort of developing itself. There was a high degree of centralization. There was sort of an expectation that there would be an increase in value of XRP based on the efforts of Ripple Labs. But in the secondary market transaction, where you were just trading with anonymous counterparties, a lot of those things didn't exist. So that was not an investment contract. So that is, I think, really a watershed moment for the industry. That's what we've been arguing in many cases for a number of years, and it's starting to get a lot of traction in the courts. And I guess the final thing that I would say on the Grayscale case, I think I agree that is very important. So unlike in Switzerland, where I've spent the past week, we have no spot ETF for Bitcoin in the United States. And it appears that this decision coming out of Washington, D.C. has sort of cleared the way, because the decision from the court was that the SEC's decision to deny the application to convert to a spot Bitcoin ETF was arbitrary and capricious. And there's great language in that opinion for those who are interested in reading it. But I think the reason why it's important, or one of the reasons why it's important, is because it really helps to sort of normalize digital asset trading. There are big entities out there that really don't want or can't custody digital assets themselves. So the fact that you can have exposure to spot Bitcoin trading activity via an ETF could potentially open the floodgates for investment in Bitcoin. And one of the challenges that we're facing in the industry is this reputational stigma that I think is going away, but it still exists, certainly in the minds of some politicians. And when you have major institutional ETFs and major institutions purchasing ETFs, that helps a lot to sort of normalize the industry sector.
Yeah, I think that's really good insight. I mean, to summarize of sorts, we're all agreeing that there needs to be clear, addressable rules and regulations for the crypto assets. The SEC is trying, we're seeing some counteraction in the courts. Let's go over to Adrian. I think one of the big concerns or issues is that security tokens, they're completely legal. We have on-chain funds that are publicly registered. We have tons of traditional private securities that have been tokenized, many other use cases. However, it always seems to be that this stigma, this reputation that crypto developed due to the lack of clarity, seems to also drag down the tokenization industry, specifically around securities and debt. Do you agree with that? Do you think crypto asset regulation needs to catch up in order for security tokens to succeed? Can it succeed without that? I do want to end on Daniel's great point about the fact that securities laws themselves, the investment contract rules, they are very old within their own regard and may require some updating in order for all of digital assets to end up succeeding properly. What do you think about that?
Yeah, I think the main issue is that the SEC is trying to fit 20th century regulations onto 21st century technology. You could have a digital asset can allow you to have a store of value. It can be a currency. It could be a ticket to an event. It could be a collectible, and all of those things could be one object, which is in a physical realm is not a possibility, but in the digital space it is. And so there's a disconnect between what we've had in the past, which, US common law, it's all based off of precedent. This is literally an unprecedented technology. And so it's going to take an unprecedented maneuver by regulators to be able to balance out the corralling of it, in that you're providing safety for the consumers that are doing it, but also allowing it to breathe enough to to foster the innovation and the potential benefits that we can reap from it. Just as a bit of a history lesson with InvestReady, we actually helped one of the first ever security tokens to launch it all the way back in the ice age of 2018. Where we had a friend of ours come to us and say, "Hey, I want to do this ICO," and then putting my lawyer hat on, obviously, like that's totally illegal and it's going to get you dinged by the SEC. But then we were able to set him up with a 506c. I think they ended up raising like $7 or $8 million through it, and I think that the token's still around today. And so there is a stigma associated a lot with crypto, and that it's associated with terrorism, or it's associated with drugs, and all the Mt. Gox stuff from back in the day with Bitcoin, and in general, that I feel has kind of made it where we have two sets of completely different customers, where we have the crypto bros, for any other to name them something, where they're very anti-government, anti-regulation, want to have the privacy of Bitcoin and everything else, and then we have the trade finance people that want to be able to utilize and digitize their space, just like every other space has been digitalized, in terms of content creation, everything else that we see in our society. One of the last bastions is the financial markets, because we have entrenched players that know what they're doing with the system that they have now. They have the pockets of the regulators and the lobbyists in Wall Street. And then we've got the up and rising crypto people on that side, which had a huge run with a lot of the bull markets that they had in the last couple of years. But I feel it's like a war between the two sides in terms of the Wall Street side, trying to basically both come into crypto and dominate it, as well as put down any potential competition from that has been sprouting up beforehand. It's a little bit of a game of whack-a-mole. I think, just to go back to the original question with XRP case, I feel that it was decided poorly, but the outcome is better for the industry. I feel that because by saying that it's not a security, you're causing more issues later on. If you were to secondary trade a stock, nobody is saying that that's not a security in terms of just a public stock that's on a secondary market, but yet having a private market for a token now and on the secondary market doesn't make it a security. I think it's going to end up getting reversed on appeal. I do like that she made it so that the appeal is not going to take place for a couple of years. So the SEC kind of has to work around that process for a couple of years and figure it out before then. My main argument, so I actually, when I saw the case was happening after the whole FTX collapse, and I saw the coming war between the factions, I was like, look, maybe using this XRP case as a vector. I ended up writing an amicus brief on behalf of the SEC nominally, but the actual outcome that I was hoping for was that XRP would get grandfathered in. It would say, yes, it's a security, but in order to figure out whether it's a security or not, they have to go through some sort of decentralization audit. So you basically, taking the four prongs of the Howey test, which are an investment of money and a common enterprise with the expectation of profits to be derived from the efforts of others, that fourth prong, if you have enough decentralization within a token sphere, like Bitcoin or supposedly like Ethereum, then there's no others to be derived from the efforts of, because it's a decentralized blob in terms of who it is that the other would be. So therefore it wouldn't then transition from being a security into a commodity at that point, and then transition its regulatory process from the SEC into the CFTC, where we basically have a way to have a process in place to show, okay, I'm doing this token. All tokens are not securities, which is another really good thing that I think came out of that case, where it's not that, okay, default, if you do a token, it's default to security. I think that would have been too far. So that at least allowed for some space there, which is what the SEC was really seeking. They wanted full control over any tokenization. They wanted it to be default security and then move into it. I think having a way to transition it from a security into a commodity, be it through the courts, be it through the SEC or regulation, be it through Congress, however we have to do it, that's going to be the way that we basically light the path to allow for these tokens to go through and say, okay, I'm making a token, I'm going to raise some funds for it through an STO, I'm going to go through this process, and then now in 2 years, if I do X, Y, and Z, it's no longer a security. I can be freely traded wherever. And there are some ways to do that, even if it were a security. But having the ability to just completely desecuritize some sort of token through a legal process that's laid out specifically, some sort of safe harbor regulation, that would allow for the market to have an understanding of exactly what it needs to do, check the boxes to have to do this particular thing, and then, okay, now I'm going to be okay with the SEC. Or if the SEC comes after me, like, look, man, I checked the boxes, you can't do anything to me. So that's what we really need at the end of the day. Some sort of, okay, this is the list. You check this box, yep, you're a security. You check this box, you're not a security. And then if you do these things, you used to be a security, but now you're not. That's really what we need. That's the clarity that's required of this industry that Gensler refuses to provide. And I think it's going to end up being forced upon him either by Congress or the courts.
Well, I got to tell you, I sincerely hope that Congress is listening to this panel. I think you're all spot on. I got about 4 minutes left with each of you, just to get some brilliant thoughts from you here as we leave. Daniel, I want to go over to you. Let's stay away from the digital asset side. Let's assume I'm one of the many people in the audience here. I represent a portfolio of assets. I'm an asset manager. I'm an entrepreneur raising money. Maybe I'm starting to start a broker dealer in order to participate in this space. How can you help us? How does your firm work with individuals looking to get into tokenization?
Yeah, well, the financial services regulatory environment, even in the traditional realm, is amazingly complex. The most well-capitalized and well-lawyered institutions in the world, the big money center banks and broker-dealers, get dinged by people like Mark. Well, he was a cub lawyer at the SEC, and his brethren there all the time, despite their best intentions. So it's very important to have knowledgeable legal and compliance counsel to help navigate that environment. So an issuer of traditional securities assets or digital assets that we regard as securities, has to consider, among many other issues, how to do a compliant offering, right? So are they going to do an offering pursuant to Regulation D, sort of a private placement type offering, or are they going to avail themselves of one of the other registration exemptions like a Reg A offering, or are they going to go for it all and try to do a public offering? And so that's just one of many threshold considerations for an issuer of securities, and there are pros and cons of each of those approaches. For broker dealers, they often require licensure with the SEC and membership with a self-regulatory organization, an SRO like FINRA. And that can be a challenging process to undertake. And I think that for early stage companies, really a piece of advice is try to get the legal and regulatory strategy right from the outset. That will save time and money in the long run. And, entrepreneurs have great ideas. The whole move fast and break things ethic has, created really an engine of innovation in this country. But when you're talking about the financial services sector and you're dealing with other people's money, my recommendation is resist that impulse at least a little bit and pause to really get the legal architecture and the compliance structure right from the outset.
Yeah, because if you break something with somebody else's money, they'll sue you.
Yeah, right.
Problem. Well, I can tell you from firsthand experience, Daniel and Kim and the whole team over with you at Winston, they're absolutely the right people to be talking to figure this stuff out. Mark, we're going to head to you for your last thoughts here. I want to ask you, you're so good at predicting things. You got such an insight onto the space. What do you want to leave us with to look forward to for 2024?
Look forward to, Daniel mentioned, the Loomis Gillibrand legislation. I think that's the one that should get the most traction and will, because it's coming from it's bipartisan. And look for that implements and puts the CFTC as the primary regulator. I think that's going to happen. I mean, SEC Gensler is a political, he's astute individual, but I'm hoping, given the fact that most of these assets are not easily characterized as securities, that's actually the place with it, and more money is given to CFTC to deal with it. The only other thing I'll mention, which is always very interesting, and to follow up on Adrian's point, is he says, there needs to be some clarity of safe harbor. Well, guess what? Back in 2020, and again in 2021, SEC Commissioner Hester Peirce put forward safe harbors precisely to address this. Chairman Gensler, if you're listening, start seriously considering her proposals, because those laid out, depending on what you become after 3 years, whether or not you need to you'll be deemed a security or not, and allow capital raising and small businesses to be able to grow with seed capital. Those are my thoughts.
I think that's absolutely fantastic. And again, for everyone listening at the STA Success Network, our research consortium, will learn more about that tomorrow. You can tune in to Marc Powers' monthly Powers Hour, where you can get these insights every month. Last but not least, of course, Adrian, I want to give you a chance to just give a little bit of a self promo about how InvestReady works with the industry, and maybe give us an illusion of what the future looks like. Maybe it looks a little bit more like, instead of you get a call from an individual and hearing a pitch in person, you might open up an email, check your compliance, and then end up buying a token. That's a very different way of investing. Tell us about how InvestReady helps power all that.
Sure. So we're primarily focused on helping people through private placement verification, though you can use it for Reg A or Reg CF. If you're an accredited investor that's been verified, you have unlimited, you're not limited in how much you actually can invest there. So InvestReady helps platforms comply with Reg D 506C specifically. We verify if someone's an accredited investor via income, net worth, or third-party letters. We handle the entire process for the issuers or platforms on their behalf, and even contact the investors if there's some sort of issue with the process. We actually just launched this past month, which happens to be our 10-year anniversary for InvestReady, by InvestReady, which is our new newsletter platform that's allowing for the issuers that send us their investors to get verified to actually reach the rest of our network with a newsletter that goes out every Monday that lists not only the deals that we get from our own issuers, but we actually pull SEC Edgar data and get all of the issuances from the past week that investors could then go in and research, call up, and get information from if they're interested in going into the Reg D 506C route. We're also allowing for anybody that wants to promote their Reg D 506C listing to get on the newsletter as well, besides just being the past week. So if anybody's running any sort of Reg D 506C and is interested in getting onto the newsletter, I think last week we sent it to over 16,000 people that we have on the list that we have permission to email. So it ends up being something that is going to allow for the space to grow, I believe, naturally. And then in terms of what's coming next, the SEC is actually under Dodd-Frank required to relook at the accredited investor definition every 4 years. They just did it in 2020, so we're expecting them to do it again in 2024. Gensler being Gensler, we think that they're going to actually raise the thresholds, so it's going to actually reduce the number of accredited investors. So we're thinking, especially with all that's happening with inflation, they're likely going to raise the thresholds and peg them to inflation. So we're talking probably going up from 1 million to 2.5 million. Probably from 200,000 to up to 500,000 with like maybe 750 for joint. That's my prediction. It may end up being a little bit higher or lower. They'll probably end up negotiating that amongst themselves. What I'm hoping for is that the Republicans on the other side that are negotiating this require them to also add the ability to have an exam that allows you to become an accredited investor. If we basically create an exam, which they could already nominally do that with the Series 65, which you're not required to be licensed in order to take, although you are required to be licensed to be able to be accredited. If they were to just say, hey, if you have a passing score in the Series 65, you are now an accredited investor, I think that opens up the floodgates in terms of people that will have informed consent to be able to go into these deals and understand what the risks are, but allows for a huge influx of potential investors that may have not qualified before because they don't have $1 million or 200,000 in income. So I think having, it's going to be a little bit of a mixed bag in terms of just having fewer investors that are eligible with the old system, but I think it's going to hopefully open up the door for new investors that can be financially sophisticated or have some sort of degree or license, like a lawyer, could hopefully potentially invest in these in the future. So we'll see what happens.
It's exciting times ahead in 2024 is what I'm hearing from you all. And not to mention, I will also say that for InvestReady, the great highlight here, folks, what I think you just heard there is this concept of passporting. Digitally investing can be instant thanks to a one-time check that you can then apply and passport to other brokers, to other platforms. For any of the blockchains in the audience, reach out to InvestReady. We've got a credit token, so we do have a soul-bound NFT we can tie to wallets in order to make sure that that wallet has been identified and is indeed accredited in order to participate in any deals. A little glimpse of the future. We're going to learn more about that later today on our crowdfunding panel. But first, we've got to move on to our next session. Thank you again to all the speakers. This was absolutely amazing. Please follow up with them, send them a message on the Zoom platform if you have any questions. And again, thank you all for this amazing panel.